Thank you for this time to allow me to speak on the topic of creating a federal publicity law that would preempt statutes that may already exist at the state level. The right to publicity has been recognized since 1977, but only 29 states to date have a semblance of a provision that protects its constituents from right to publicity. Right to publicity goes a step further from damages associated with the privacy cases. It goes beyond emotional distress and becomes an issue of economic injury. With this leap into economic injury, we enter a gray area where who is considered a public figure and how do you prove economic harm? All citizens need protection from economic harm, but public figures have come to rely on their personal image and likeness as an asset, which should be protected as any other asset, which not only allows them to prosper as individuals, but unprotected could allow others to prosper on their behalf, which basically is stealing. Publicity rights are property rights, but by putting a federal law into place, it would allow individuals to protect themselves from the unauthorized commercial use of their persona, which may include their name, photograph, voice, signature, or other aspects of their public image. This is why public figures are most affected by the need for such a law. The damages in a publicity case are based on fair market value of the harm done to the plaintiff themselves. The biggest issue with publicity statutes among all 29 states is that there's no best practices or overarching principle to follow. A case that is won in one state could potentially be thrown out in another state with the same infraction being committed. As previously mentioned in the digital age, the infractions can be instigated from anywhere, any place, but affect the same people. Although there is a trend toward more states recognizing a right of publicity, there is a dramatic lack of uniformity concerning the scope and substance of the rights of publicity recognized by different states. For example, the New York civil rights law prohibits the use of the name, portrait, or picture of any living person for advertising purposes or purposes of trade without the individual's prior consent. This right is not descendable in the state of New York, whereas in the California Civil Code, it prohibits use of another's name, voice, signature, photo, or likeness in any manner or in products, merchandise, or goods for purposes of advertising or selling or soliciting purchases of products, merchandise, or goods, or services without such person's prior consent. Originally, this right was not descendable in California either. But in 1995, California elected to extend the right to publicity to 50 years past death, and in 1998 extended it to 70 years past death. These types of contrasting laws offer too many potential infringements against the rights of public figures to go unresolved, which is why the need for a uniform federal protection against the violation of the right to publicity is essential. Kevin L. Vick and Jean Paul Jassy expressed in a journal for the American Bar Association that when acting within constitutional limits, Congress is empowered to preempt state law. For example, the Copyright Act does preempt state law claims that fall within the general subject matter of copyright law and seek redress of rights equivalent to the exclusive rights in Section 106 of the Copyright Act. A federal right of publicity statute should preempt state laws in the same way, especially in the digital age where state boundaries do not exist, when all forms of media can be viewed and published from the comfort of one's home in any state. Thank you again for your time.